Hello students, my name is Aditya Gupta and I am a lawyer at the Delhi High Court. Today we will be studying the module on the limitations on the rights of trademark owners. By the end of this module, I hope you will be able to understand the defenses that a person who is sued for trademark infringement can take and the various sections which are provided in the Trademarks Act for this purpose. Let's first go on to Section 30 Clause 3, which deals with the doctrine of the exhaustion of rights. Let me start by giving you an example. Let's say you go to a store to buy a printer of a multinational company, and then your colleague asks you for a resale of that printer and offers you a great deal. You decide to sell the printer to him, but then you're worried, will the sale of my printer, the printer that I have bought, amount to an infringement of trademark? Section 30 Clause 3 deals with this kind of an issue. It deals with the doctrine of exhaustion of rights. What do I mean when I use the term exhaustion? Exhaustion means, do the rights terminate or exhaust after the goods which bear that trademark have been sold for the first time. This is why this doctrine is also called the first sale doctrine. So the question to be asked is, do trademark rights continue to exist after the first sale of the goods? Also remember, when we are talking about the exhaustion of rights, it is only about exhaustion of rights in a particular set of goods, not across the goods. Therefore, even if the answer to your earlier question was in the affirmative, that is, you could sell the printer to your friend, it would not mean that the trademark rights of the trademark proprietor would be exhausted with respect to all printers. It would only mean that the trademark rights would get exhausted with respect to that particular printer which has already been sold to you. Now let's try and understand the different intricacies involved in the doctrine of exhaustion of rights. There are two types of regimes. One is national exhaustion and the other is international exhaustion. What do I mean by these terms? Well, it is important for you to first understand that the laws in most countries, including the law in India, recognizes that there needs to be some sort of exhaustion. That is, whether national or international. The debate really revolves around the geographical extent of exhaustion of rights. Let's deal first with the doctrine of international exhaustion. If the doctrine is considered to be one of international exhaustion, then goods bought anywhere in the world would lose their trademark rights in India as soon as the first sale is made. So, for instance, you bought a printer in Singapore and then imported the same into India and then sold it to your colleague in India. That would mean if the doctrine of international exhaustion is adopted, that sale would not be trademark infringement. Of course, it is important to remember that when we talk about exhaustion of rights, it's not usually with respect to an individual consumer like you. Many businesses are based on this business model wherein goods are bought in another country where they're sold at a cheaper rate and then imported into India and then sold in India. And that is why this doctrine becomes relevant, because it is not only about individuals but about businesses. Let's now go on to the doctrine of national exhaustion. If India adopts the doctrine of national exhaustion, then we would say that the printer purchased in Singapore cannot be sold in India without the consent of the trademark proprietor. However, a trademark bought in Bombay can be sold in Delhi without the consent of the trademark proprietor. Therefore, national exhaustion means that the geographical extent of the trademark rights would be limited to India, and a proprietor does not lose trademark rights when the goods are bought in other countries. The big question is, does India follow international exhaustion or national exhaustion? The relevant provision that you need to look at for this purpose is section 30 clause 3. Unfortunately, the section itself does not really specify whether India follows national exhaustion or international exhaustion, and therefore we are left to judges to interpret the intention of the legislature and come up with this really important answer. The Delhi High Court has dealt with this provision in the Samsung versus Kapil Wadhwa case. The single judge of the Delhi High Court, Justice Manmohan Singh, held that India follows the rule of national exhaustion. In this case, the Delhi High Court was considering the question whether goods imported by the proprietor, by the defendant from abroad, can be sold in India without it being considered infringement of Samsung's trademark. The goods involved in this case were also printers, and they were being sold commercially by the importer who had got the goods from abroad. Also, it's important to note that these printers were being sold at a much cheaper price as compared to the price at which Samsung is offering its printers in India. The Delhi High Court decided this matter in two phases. First, at the lower court level, a single judge of the Delhi High Court, Justice Manmohan Singh, decided this issue and held that by a reading of section 30 clause 3, it seems that India follows the principle of national exhaustion. He relied on the decisions of many countries and also looked at several policy considerations before reaching his decision. He also acknowledged that the statute by itself is not very clear. That is, section 30 clause 3 by itself is not very clear as to whether India follows the doctrine of national exhaustion or international exhaustion, but by reading several other provisions in the statute, he came to the conclusion that India does follow the principle of national exhaustion. Therefore, the defendant who was selling goods which were bought from abroad was liable for infringement of trademark, since Samsung did not lose its rights in the goods which it had sold abroad. The defendants went in appeal against the decision of the single judge. The appellate court, that is a two-judge bench of the Delhi High Court, decided that India follows the principle of international exhaustion. They said that because of the statement of objects and reasons, it seems that the legislature intended that India follows a principle of international exhaustion. Therefore, the court held that the defendant must be exonerated of all liability if it buys goods abroad and then resells them in India. The case is currently pending before the Honorable Supreme Court, and this is one case which all trademark lawyers are really watching out for. As a student, I would recommend that you also watch out for this case and do read it when the decision is passed by the Honorable Supreme Court. Another interesting question: apart from the legal arguments, what is more beneficial from a policy perspective? One thing that you may remember from my earlier lecture is that the printers being sold by the defendant were cheaper as compared to Samsung's printers. This means that sometimes following the principle of international exhaustion can prove beneficial to consumers. But unfortunately, this is only half the story. You must also remember that it is important for a trademark owner to be able to regulate the channel of goods through which the goods are sold. it is important for a trademark proprietor to be able to regulate the channel of goods through which its goods are sold. Let me tell you the reason why. This is because a trademark proprietor does not only sell the goods to the consumer, it also provides after-sales service, warranty, and other services to its consumers. This means that if there is any defect in the goods and the trademark proprietor is not able to offer warranty or after-sales service because it was not through the regulated channels, the consumer would end up blaming the trademark proprietor, and this would mean that the value of the trademark will diminish because consumers will feel that the goods of a particular trademark are not as worthy as they seem. Let me take the Samsung versus Kapil Wadhwa example. Let's say a consumer goes to the defendant's shop and buy a parallelly imported Samsung product. Because Samsung offers regional warranties, it would mean that a good purchased in Singapore will not be offered warranty in India. This would mean that the person who buys the printer from the defendant in India would not be able to avail the warranty on the Samsung printers in India. Therefore, if there is any defect in the Samsung printer, or if the consumer needs any after-sales service and if he is not able to get it because of this difference in regional warranty, the consumer would not blame the defendant. The consumer would in fact blame Samsung, and Samsung's brand value and trademark would both be diluted. This is why, while trademark exhaustion does allow consumers to buy goods cheaply, it may also in certain cases cause harm to the trademark proprietor, and this is why companies like Samsung and many other companies who operate internationally are hoping and are looking towards the Supreme Court towards holding that India follows the principle of national exhaustion. Let's wait and watch and see what the future holds. I now need to tell you about the doctrine of material differences. This doctrine is contained in section 30 clause 4 of the Trademarks Act. According to section 34 clause 4 of the Trademarks Act, if the condition of the goods which are being resold is changed or impaired, or if there are any other legitimate reasons for the trademark proprietor to oppose the resale of those goods, then the immunity under section 30 clause 3 would not be available. The question is, when are the goods considered to be changed or impaired, or what are the legitimate reasons that a trademark proprietor can take to oppose the resale of the goods? It is possible, though it is not settled by courts in India, that the lack of warranty or the lack of change in the condition of the goods will be considered a material change or impairment which would allow a trademark proprietor to oppose the resale of the goods. I will take an example from another jurisdiction. In the US, Nestle chocolates were sold in a particular condition. Nestle likes its chocolates to be in perfect condition when they reach the consumers, and thus it maintains the temperatures of its chocolates at a particular level to ensure that the chocolates are not melted when they reach the consumers. In that particular case, the chocolates which were being sold through another channel of goods, because of which the chocolates melted, since the defendant did not maintain the temperature of its trucks which were transporting the chocolates at a particular level. Owing to this, Nestle sued that defendant and said that the condition of the goods was materially impaired and this was causing loss to Nestle. The court said yes, this amounted to a material difference or a material change, and thus held in Nestle's favor and said that the doctrine of exhaustion of rights will not apply. What will be these changes or impairments or legitimate reasons is an open question, which again the Supreme Court will probably answer when the Samsung case is decided in the near future. Let's now move on to the next doctrine. I would like you to read section 30 clause 2 clause E of the Trademarks Act, section 28 clause 3 of the Act, and section 124. Before proceeding, please have a look at these sections. According to section 28 clause 3, it appears that if there are two persons who are registered proprietors of a trademark, then they will not be able to sue each other. You would be wondering at this stage, how can there be two persons who can be the registered proprietors of the same trademark? After all, section 11 of the Trademarks Act prohibits the registration of a trademark which is similar to an already registered mark. Unfortunately, despite this provision, one finds that the trademarks registry still registers many trademarks which are similar to one another, and this gives rise to a situation where two proprietors are registered for same or similar trademarks. That's why section 28 clause 3 tries to deal with this situation. According to section 28 clause 3, the two trademark owners will not have rights against each other for infringement of a trademark, but they will continue to have rights against all other parties, that is, against the world, with respect to their respective trademarks. This is the doctrine under section 28 clause 3. Similarly, under section 30 clause 2 clause E, a person can take the defense that he or she is a registered proprietor of a trademark and thus he is entitled to use the trademark. I'll explain this concept to you by means of an example. Let's say there's a person who is the registered proprietor of the trademark Gopal Sweets for sweets. Consider that another person goes to the trademark registry and registers the trademark Gopal for sweets. Is it possible for the first proprietor to stop the other proprietor from using the trademark Gopal? It would seem from section 28 clause 3 and section 30 clause 2 clause E that this is not possible. The subsequent proprietor can always take the defense that being a registered proprietor of a trademark, it cannot be stopped from using the trademark for which it is registered. But there is a catch here. You now need to see section 124 of the Trademarks Act. Section 124 contemplates a situation where a suit for infringement of a trademark is filed against the registered proprietor of a trademark. This itself is our first clue. It seems that the suit for infringement of a trademark can be filed against the registered proprietor of a trademark. Secondly, section 124 provides that if a suit for infringement of trademark is filed against a registered proprietor of a trademark, proceedings for finding that the trademark is invalid can be instituted by the first registered proprietor. That is, the plaintiff can say that the defendant's registration is invalid. This may be for several reasons, such as section 11 of the Trademarks Act or section 57 of the Trademarks Act, which deals with non-use. This would mean that since the defendant's registration is under challenge, the court would stay the proceedings and allow the plaintiff to file appropriate proceedings for finding that the registration of the trademark is invalid. But this leads us to the question as to what happens to section 28(3) and section 30 clause 2 clause E. All these provisions have been reconciled by the Delhi High Court in the case of Clinique versus Gufic. Therefore, these provisions need to be reconciled. The Delhi High Court in the Clinique versus Gufic case attempted to reconcile all these provisions. I have culled out the ratio of that decision and I will go through each of these points one by one. First, the Delhi High Court said that there can be a suit for infringement against the registered proprietor of an identical or similar trademark. Secondly, upon the defendant taking the plea of his registration and of there being thus no infringement, the suit for infringement has to be stayed awaiting the rectification proceedings. This means that if the plaintiff files invalidity proceedings against the defendant, then the suit for infringement will have to be stayed. It is important to note that only the trial of the suit will be stayed. This is because of section 124 clause 5, which says that the court remains empowered to pass any interim order, including the grant of an interim injunction. Lastly, and this is important, the court, while passing an interim order, will necessarily have to prima facie adjudicate on the validity of the two competing registrations. That is, the court will have to prima facie see whether the plaintiff's and the defendant's registrations are valid. This is because section 31 of the Trademarks Act specifically says that the registration is prima facie valid in evidence of validity. However, in attempt to reconcile all these provisions, the court will have a prima facie view whether the defendant's registration is valid or not. This, of course, is the opinion of the Delhi High Court, and we are yet to see a decision from the Supreme Court in this regard. However, it does seem that the Delhi High Court has provided a correct answer on the way to reconcile all these sections. Now let's move on to the other limitations under subsections of section 30. The next limitation is regarding the descriptive use of a trademark. It is important for you to understand the distinction between the descriptive use of a trademark and the trademark use of a trademark. When you use the trademark to describe the kind of goods, the quality of goods, the quantity of goods, the purpose of the goods, the value of the goods, the origin of the goods, or the time of production of the goods, when a particular trademark is being used to identify the source of the goods, then it amounts to trademark use of the particular mark. For instance, if you take an Apple phone and see the Apple logo on that phone, it attempts to show that the phone originates from the Apple company. However, let's say someone else is making Apple iPhone chargers and says on its charger that the charger is for use in an Apple phone. Let's say the use is not in a trademark sense to the extent that there is no prominence which is given to Apple or the logo on the charger. In these cases, it would be considered a descriptive use of the mark. So therefore, you can use a mark in such a sense that it indicates the kinds of the goods, or the quality of the goods, or the quantity of the goods, or the intended purpose of the goods. Here, for instance, the intended purpose of the charger is for that it can be used for Apple phones. Thus, the use of the term Apple with respect to the charger will not be considered an infringement. Let me go on with the list. You can use the mark with respect to show the value of the goods, the geographical origin of the goods, the time of production of the goods, or other characteristics. There is a very important caveat here. You cannot use the trademark in a sense by giving it any prominence, but it is important that these trademarks must be in the same font, must not be given any emphasis when they are being used on the chargers. Therefore, at best, the person can write for use in Apple phones without any emphasis on the word Apple whatsoever. Some examples of the descriptive use of a trademark. For instance, the trademark sugar free. In this case, what happened that a subsequent person wanted to use the trademark sugar free with respect to cookies. You might have heard of the sugar free tablets, which are used for lowering the sugar content which is given to consumers. The defendant in that case took the defense that he is merely trying to describe the characteristics of his cookies which are free of sugar. The court agreed. The court said that the use of the mark sugar free was only a descriptive use and did not infringe the trademark of the owner of the mark sugar free. Another example is the trademark low absorb. This trademark was used with respect to oils. The court said that even though the plaintiff had the registration for the mark low absorb is only describing the characteristics of the good, and therefore the use of the trademark low absorb would not amount to infringement of the plaintiff's trademark. Let's now move on to the next exception. The next exception is the non-brand use of a trademark. For this purpose, please see section 30 clause 2 clause D of the Act. It says, a trademark is not infringed where the use of a trademark by a person in relation to goods adapted to form part of or to be accessory to other goods or services in relation to which the trademark has been used without infringement of the right given by the registration under this Act, or might for the time being be so used if the use of the trademark is reasonably necessary in order to indicate that the goods or services are so adapted, and neither the purpose nor the effect of the use of the trademark is to indicate, otherwise in accordance with the fact, a connection in the course of the trade between any person and the goods or services as the case may be. Unfortunately, the section is quite long and complicated. Let's try and break it down. What this section really means is whether a person can use the trademark of another to show that the goods that he is selling are adapted or are in some way connected to those goods. Let me give an example. There was a person who was making gaskets for Hawkins cookers. He wanted to use the term Hawkins on his gaskets, on the packaging of his gaskets, to show that those gaskets are compatible with Hawkins cookers. The court was then considered the question, when would it be that the case of use of the trademark being reasonably necessary in order to indicate that the goods are adapted to another? The court said that it must be reasonably necessary, with necessary meaning inherent in the situation and reasonably meaning that it should be just. In that particular case, the gaskets were not only adapted to Hawkins cookers but to several other cookers. The court said that since the goods were compatible with many manufacturers, it was not reasonably necessary to use just one manufacturer's trademark, and therefore section 30 clause 2 clause D did not come to the aid of that particular defendant. But I hope you understand the general principle. When you are making goods which are compatible with the goods of another manufacturer, you may be able to use the trademark of that other manufacturer, but again the same caveat applies that you cannot use the trademark of another manufacturer in a larger font, or with any emphasis. You can only use the trademark to show that your goods are compatible with another manufacturer. This is called the non-brand use of a trademark. Now let's move on to the other exceptions mentioned in section 30. This one is pretty obvious, where the use of the trademark falls outside the scope of trademark protection. For instance, sometimes trademarks are registered with geographical limitations. Let me give you an example. Let's say there is a sweet shop in Delhi by the name of Gopal Sweets, and Gopal Sweets is the best sweet shop in Delhi, and people immediately know that a particular sweet comes from Gopal Sweets when they eat it. Clearly, Gopal Sweets is distinctive and people associate the particular goods with a particular trademark. However, there may be several Gopal Sweets all over the country. Therefore, when Gopal Sweets in Delhi will want to register a trademark, it will probably have to tell the trademarks registry that it will only protect the trademark within Delhi but not in other parts of the country. This would also mean that if some other Gopal Sweet comes up in another part of the country, it will not infringe the trademark rights of the proprietor in Delhi. This is the second to last limitation. Let's move on to the last limitation. What if you apply the trademark to goods which originate from the proprietor? For instance, the proprietor sells the goods not in loose packets but in large bulk pieces. What if while reselling those goods, you apply the trademark of the proprietor on those individual pieces? In absence of section 30 clause 2 clause C, it would amount to trademark infringement. But under section 30 clause 2 clause C, if a trademark is applied to indicate the true origin of the goods, then it does not amount to trademark infringement. Let's now summarize the different limitations that we have studied today. We first studied the limitation of doctrine of exhaustion of rights, under which the rights in a trademark get exhausted after the first sale of the goods. The question is whether India follows the principle of national exhaustion or international exhaustion, and the Supreme Court will consider this question in the near future. The next limitation is with respect to suing the registered proprietor of a trademark. There is a lot of ambiguity because there are different sections which seem to say different things. But the Delhi High Court has recently reconciled all these provisions and come to the conclusion that while a suit for an infringement of trademark can be filed against a registered proprietor, the court will have to look at the prima facie invalidity of the trademarks of the defendant's registration before passing any order of interim injunction. Then we talked about the descriptive use of the trademark and where a trademark is used to describe a quality of the goods. You may recall the sugar-free example where the defendant were using the trademark sugar-free to merely describe the characteristics of the goods and thus was not held liable for trademark infringement. The next limitation is with respect to the non-brand use of a trademark. Here we discussed the Hawkins example. It is important to know that a non-brand use of a trademark must be reasonably necessary, and thus it is usually a difficult defense to take. The last limitation that we studied was with respect to the use of a trademark on the registered proprietor's goods. You may recall the use of a trademark on individual packs when a bulk pack is bought from the trademark proprietor. Where the trademark is used to indicate the true origin of the goods, it does not amount to trademark infringement. I hope now you have a sense of the defenses that are available to a defendant when it is sued for trademark infringement. Thank you.